America, national or federal? Each state, in ratifying the Constitution, is considered a sovereign body, independent of all other, and only to be bound by its own voluntary act. In this relation, the new Constitution will, if established, be a federal and not a national constitution. Federalist number 39, James Madison. In search of liberty, liberty, sir, is the primary object. The battles of the Revolution were fought not to make a great and mighty empire, but for liberty. Patrick Henry. Superior law, higher law, my law. You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by human laws, rights derived from the great legislator of the universe, John Adams. Introduction to corporate political society. Finally, be strong in the Lord and in the strength of his mighty. Put on the whole armor of God, that you might be able to stand against the wiles of the devil. For we are not contending against flesh and blood, but against principalities, against the powers, against the world rulers of this present darkness, against the spiritual hosts of wickedness in heavenly places. Ephesians 6:10 through 12. Introduction to Law of Merchant. Stand fast, therefore, in the liberty with which Christ hath made us free, and be not entangled again with the yoke of bondage. Galatians 5:1. Society of slaves and freemen. If men, through fear, fraud, or mistake, should in terms renounce or give up any natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation, the right to freedom being a gift of Almighty God. It is not in the power of man to alienate this gift and voluntarily become a slave. Samuel Adams, 1772. Sovereignty. Even in almost every nation which has been denominated free, the state has assumed a supercilious preeminence above the people who have formed it. Hence, the haughty notion of state independence, state sovereignty, and state supremacy. Justice Wilson, Chisholm versus Georgia, 2 Dallas, U.S., 419, 458, 1792. Legal system for sovereign rulers. Shall judge the people with equity. Psalms 98:9. The negative side of positive law. Therefore, one must be wise and attentive, since there are those among us who make kings and set up princes outside his law. Hosea 8:4. Liberty. Now the Lord is that Spirit, and where the Spirit of the Lord is, there is liberty. 2 Corinthians 3:17. When there is no money, for thus saith the Lord, ye have sold yourselves for nothing, and ye shall be redeemed without money. Isaiah 5:3. The natural orders of things. Owe no one anything except to love one another, for he who loves his neighbor has fulfilled the law. Romans 13:8. Resident minister. You may also buy some of the temporary residents living among you and members of their clans born in your country, and they will become your property. Leviticus 25:45. Agree with thine adversary quickly while thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence till thou hast paid the utmost farthing. Matthew 5:25-26. What does accepted for value mean? Accepted for value, A for V, is at the foundation of remedies available for commercial demands made by the United States. So many people have attempted to use it to close accounts in the United States. Even so, no one has had a good explanation of what A4V means. Here is an attempt to clarify. Introduction. The Uniform Commercial Code in Article 3 that deals with negotiable instruments is one source of explanation. Article 8 deals with investment securities, and Article 9 deals with the secure transactions. In addition to judges to shed light on our remedies, all three of these articles hold a key to understanding commercial setoff. The UCC had an overhaul in 2000, but the major principle remained the same. The changes appear to be to the sections that deal with secured transactions, Article 9, and some with investment securities, Article 8, but negotiable instruments are what lead to those securities. The phrase accepted for value has little coverage in the code books or in the court opinions. A better understanding of commercial terms, acceptance, and value, and how they relate to instruments in general would be a good place to start. Acceptance. An agreement either by express act or by implication from conduct to the terms of an offer so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counteroffer. Black's Law, 7th edition. Accept. To receive with approval or satisfaction, to receive with intent to retain. Black's 4th. Acceptance. The taking and receiving of anything in good part and, as it were, a tacit agreement to a preceding act which might have been defeated or avoided if such acceptance had not been made. Black's Law, 4th edition. A naked acceptance waives remedies that are available by waiving defects in the instrument, agreement, or contract that is being offered and accepted. Instrument is an acceptance and a taking. Retention is the basis for a binding contract if there is a preceding act like a pledge to the United States. Altering the terms of the instrument and returning it operates as a counteroffer. UCC 1-201 General Definitions 44 Value. Except as otherwise provided with respect to negotiable instruments and bank collection, sections 3 UCC 3, UCC 4-210, and UCC 4-211, a person gives value for right if he acquires them. A. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection, or B, a security for or in total or partial satisfaction of a pre-existing claim, or C, by accepting delivery pursuant to a pre-existing contract for purchase, or D, generally in return for any consideration sufficient to support a simple contract. UCC 1-201-44 generally says that a person gives value, he gives value to get rights. If one person is giving value, another person is asked to give rights in exchange. Both giving value and giving rights meet the element of consideration. The question has to be, what constitutes value? In today's commercial system where ownership is not the prime focus, interest, rights, in things take the place of ownership as the goal. A security interest constitutes a right to seize control of a pledge thing if the one giving the security interest fails to perform as agreed. The one giving a security interest retains possession of the thing that secures the right of another party to seize possession of the thing that backs the security interest that was given. The one receiving a security interest becomes a secured party, especially if the instrument establishing the security interest is registered. He has rights, which are remedies and defenses that he can use to enforce an agreement if the other party fails to perform as agreed. UCC 1 201, General Definitions 36, rights includes remedies. A remedy is a commercial right for those who acquire that right through an instrument. In, cor- in corporate United States, there must be a written record of everything. Nothing is supposed to be assumed or presumed, but that does not mean assumptions and presumptions are not used every day to acquire rights and enforce them. If the right that is being enforced is a security interest in a tangible or intangible thing, it usually comes from an instrument that is actually supported by the thing. This is usually, but not always, a pledge or a promise to relinquish possession of a thing if there is a breach of the agreement or contract. Because enforcement of a contract based on an implied promise is weak, an instrument demanding performance on it is an offer to initiate a new contract based on an old antecedent and maybe implied or unenforceable contract. If an instrument is based on an intentional written promise to perform and an intentional pledge to relinquish property, it does not have to be issued for value. It is just issued, and the original contract with the offerer's right to pledge property is the consideration that supports the demand. A copy of a written promise and pledge can be attached to the instrument, or the instrument can just refer to the contract by its title, number, or date, etc. The issuer of the instrument demanding performance supported by a written promise has defense if the debtor files a complaint against the issuer for making the demand. The issuer can produce the antecedent contract that contains the initial promise to perform and the initial pledge to use tangible or intangible property to secure that performance. If the debtor is aware that he made previously signed a promise and pledge his rights to a thing to guarantee his performance, he would not have to see the contract. The demand instrument is issued to get performance already promised, or, in the alternative, to get the thing already pledged. In some cases, there is no pledge to support an instrument, so it must be issued and transferred for value with implied consideration. There is no debtor. The issuer does not have a written instrument to back his demand instrument. If he decides to issue the demand instrument in spite of his lack of authority, he is risking liability on the instrument. If the transferee, the one who the issuer directs the demand to, calls the issuer's bluff, the issuer can be made to pay the transferee. The transferor has no defense. He has no antecedent contract to attach as consideration for the demand he is sending to the transferee. If the issuer has no written pledge but still decides to issue a demand, the demand instrument must be issued for value because there is no evidence of pledge to attach to it. There is no written antecedent contract obligation that requires the transferee to perform, but he still has to do something with the demand. The transferee is the one who receives the instrument by mail, by process server, or by warrant. The transferee is a target. The issuer is shooting the instrument at the target, hoping the target will just take the shot and agree to become liable on the new offer. The issuer is bluffing. If the transferee recognizes the demand instrument as a bluff, he can call the issuer on the bluff and require the issuer to pay. The transferee actually gains a security interest in the instrument if he recognizes it. If the instrument is issued and transferred for value with implied consideration, the transferee acquires a security interest or other lien on the instrument if it was not obtained by judicial proceedings. See UCC 3-303. If you properly endorse an instrument issued and transferred for value, you acquire a right to enforce the instrument against the issuer. You become the creditor by returning it to the issuer, who becomes the debtor. By accepting the instrument and offer for value, you are altering the term of the offer and it becomes a counteroffer. Acceptance. If an acceptance modifies the terms or adds new ones, it generally operates as a counteroffer. Black's Law, 7th edition. The right to be the creditor is what you get when you A for V an instrument that is issued and transferred for value, like a tax bill, penal action, indictment, or speeding ticket. These issues are all based on violations of statutes. Dishonor has value in the public. Violation of statutes has value in the public. The violation of the statute is the presumed basis consideration for issuing the instrument. But if you have not promised to perform under those statutes, you are not obligated, and the issuer has no way of supporting his demand instrument. It is issued without consideration. It is issued based on a presumption that every U.S. citizen has pledged allegiance to the United States and to its private laws, statutes. It is a bluff. The river card has already been turned. You have the winning hand. You can call the issuer's bluff. You can check, you can raise, you can fold. It is your choice. You have the button. The commercial system of the United States is based on the law of merchant. That law is not neutral. It is not set up to be fair. It is set up to facilitate collections for creditors, especially foreign creditors. It deals with debtors and creditors, even when there is no debtor-creditor relationship. The only thing that has to be determined in most situations is who is the debtor and who is the creditor. Once that is determined, additional facts are usually irrelevant and immaterial. In the United States, every man is deemed to be a U.S. citizen, and every U.S. citizen is deemed a debtor. A for V is one way to establishing that you are a creditor and not a debtor. If you are going to use the law of merchant to settle disputes with the United States, a firm understanding of the law of merchant is necessary. If you have commercial rights, to trier of facts in a commercial dispute will proceed cautiously to avoid denying you commercial due process. Commercial due process is not much more than time and opportunity to complete an administrative remedy and produce a counterclaim. If you don't know what your administrative remedies are, you probably don't have any commercial rights to exercise. As one who represents a person in the United States, i.e. U.S. citizen, you have due process rights through the sovereign statutes. As a man in the several states, you have due process rights through your creator's natural order of things. Properly applied, commercial remedies incorporate the natural order of things. You can choose to use a sovereign statute or commercial remedies, but they should not be used simultaneously. They're like oil and water. They don't mix. If you are going to use commercial remedies, injections of statutory rights will kill your commercial due process remedies. The terms, the offerer, and acceptance make the law that will be enforced. Even though you might choose to use commercial remedies, you still need to use the person you represent in the public to access the commercial remedies. They have been statutized in state law. You can use them, but you cannot cite the source. The statutes use the natural order of things as the basis for their code section, and then incorporate the private policy code section into the same set of published statutes. If you use the site UCC or USC, you have reverted back to being a U.S. citizen taking a benefit from the statutes. If you demonstrate the principle in the code section without citing it, you maintain your separation. The person you represent in the public acquires the commercial rights, but you interject your rights through the natural order of things and maintain your unalienable rights. You get to use the person instead of it using you. A person can acquire commercial rights through several means. According to the definition of value above, he can acquire them A, in return for credit, B, as security, C, through the delivery pursuant to a contract, or D, in return for any consideration. Each of subsection A through D deals with different scenarios. The last one, D, is a general catch-all that covers anything that might not have been addressed by the first three. The definition is one of the most confusing in the commercial code and is one of the most important to understand. A right is defined as a remedy. Debtor's remedies often include defenses against foreclosures on the express or implied terms of an express or implied agreement for which security was given. Defenses are often given to debtors as consideration by creditors, and defenses are often given to creditors as consideration by debtors. Money and things are not needed under the commercial system where interest in things like real estate, bank accounts, and bodies serve as consideration. For example, a creditor may sign an agreement giving possession of a product to a debtor before the debtor has paid for the product. In that case, the debtor has defenses if his creditor later accuses him of taking the product without paying for it. In the same transaction, the debtor may give defenses through the agreement to his creditor. If the debtor later claims the product he received was not what he ordered, the written agreement identifies what the debtor actually ordered. The agreement will specify the terms of the agreement and the defenses each party gives to the other. Those defenses are rights that will result in a remedy if one of the parties is later wrongly accused of a breach. The people have the commercial rights if they are accused of a breach of some unknown contract. The accuser might claim a security interest in an antecedent claim against property supposedly pledged as security in exchange for value that was supposedly given by the accuser. That kind of claim would have to be issued for value because the accuser would have no written agreement as the basis for his claim. His claim would be a new offer. He would be trying to get you to join in a new contract by implying that an antecedent contract existed. Since it does not exist, the issuer of the new offer has to be bluffing. A for V is based on contract law. If you think there is a presumption of a pre-existing contract through which you are presumed to be a debtor that has supposedly pledged property and your liberty as security for some presumed value given by the United States, it might be very important for you to negotiate some better terms in a counteroffer. If the issuer of the instrument for value does not counter your counteroffer, you are in a much better position. If you have a record of a valid contract that contains terms in your favor and can be enforced in commerce, you have remedy or remedies. If you don't, the United States may be entitled to enforce a different agreement. Even if you have an agreement advantageous to you, your actions may imply a waiver and your consent to abide by less advantageous agreement. Pre-existing or antecedent claims can be created by agreement between the actual parties, but when the United States is a party, all agreements incorporate an attachment to the national debt. An antecedent claim other creditors have against the United States. It is like a program running in the background on your computer. The presumption that all U.S. citizens have pledged allegiance to the United States and its statutes is enough to establish an antecedent claim in favor of the United States. U.S. citizens cannot question the national debt. They're called upon to be surety for that debt, and they usually lose when a court proceeding is initiated against them for violations of statutes. This is done on the principle that the United States is more likely to pay its debt if it can collect from its debtors. United States courts take jurisdiction of cases where a debtor to the United States is being charged with violations of the United States statutes, even though a U.S. citizen does not have a direct obligation to the creditors of the United States. Through the principle of novation, U.S. citizens generally agree to be liable without knowing they have done so. A person can transfer his rights and obligations to another party through agreement. A owes B, or A or B can ask C to take on A's obligation. If C agrees and A and B are given notice that C has agreed to owe B and A owes B, the novation is complete and A is relieved of the obligation of paying B. The U.S. citizen is C in this example. A, the United States, and B is the creditors of the United States. The commercial code is first and foremost concerned about repayment of the national debt as a pre-existing contract with an antecedent claim. The secondary function of the commercial code is to provide an orderly method of dealing between other debtors and creditors. United States Code statutes violations are claims used by creditors of the United States to collect internal revenue from U.S. citizens to pay the national debt. There can be claims stacked on claims. It is not uncommon for a totally discharged debt to be renewed by a creditor without the knowledge of a debtor. United States statutes are designed to transfer private rights from the private to the public for public use to pay the national debt. Every evidence of a debt in the United States has value. Persons in the United States carry on commercial transactions by giving and receiving value. Value has nothing to do with things until there is a breach of an agreement. When an interest in a thing is transferred from the debtor to the creditor on the private side, a thing is an object that casts a shadow on the public side. Only the shadow can be seen. On the public side, the shadow is given value. Interest in the thing is the value. It's not the thing. Value, UCC 1-201. UCC 1-201, General Definitions 44, value, except as otherwise provided with respect to negotiable instruments and bank collections, sections 3-303, 4-210, and 4-211. A person gives value for rights if he acquires them. A, in return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection, or B, as security for or in total or partial satisfaction of a pre-existing claim, or C, by accepting delivery pursuant to a pre-existing contract for purchase, or D, generally in return for any consideration sufficient to support a simple contract. Subject A of UCC 1-201-44 can be read from the perspective of either a lender or a borrower as the one extending credit. Both parties receive rights from the agreement. Only the people have the energy needed to create money in the United States. And in today's system, credit and security interests circulate as money. Creation of money remains in the same place it always was, with the people. Before 1933, the people dug the gold and silver out of the earth, took it to any asir to have it coined by authorized agents of the United States, and spent or loaned their coins into circulation. Since 1933, the people signed notes on their own credit, have that credit converted into currency by authorized agents of the United States, and spend it into circulation. After signing notes on their own credit, the people usually get into another unintended contract and agree to give a security interest in something as value on a contract they don't need and don't even want to enter. Articles 1, Section 8, Clause 2 authorizes the Congress to borrow money on the credit of the United States. The United States, in that clause, necessarily must refer the several states, as the government has no means of securing credit on its own. The people compose the several states. That clause authorizes the Congress to borrow money on the credit of the people. Both parties receive value in a transaction, and both parties receive rights. Both parties give value, and both parties give rights. Value usually means some kind of consideration. Article 3 of the Uniform Commercial Code further clarifies value when negotiable instruments are involved, but the more general definition in Article 1, Section 201, the next section contains many examples of exchanges of value for rights, and conversely, exchanges of rights for value. Value is a complicated concept, so several examples are given to help to clarify. Value is subtle, so note the subtleties of the example. The specific value for each example is bolded. The following interpretation for subsection A through D deal with persons and credit under public policies through the law merchant. UCC 1-201, General Definitions 44, Value, except as otherwise provided with respect to negotiable instruments and bank collections, subsection 3-303, 4-210, and 4-211, a person gives value for rights if he acquires them, A, in return for a binding commitment to extend credit or for the extensions of immediate available credit, whether or not drawn upon, and whether or not a chargeback is provided for in the event of difficulties in collection. A person gives value to another party in exchange for interest in the other party's property. He acquires rights interest in return for giving a binding commitment to extend credit, or giving a binding commitment for the availability of credit to the party giving the person the rights. Those rights might be in title to real property or for capacity to sue to get the title to real property through court order. Those rights might be in benefits provided by the United States. They might be a distribution from the trust created by the Constitution. It does not matter if the party giving the rights draws on the commitment to extend credit. It does not matter if a chargeback is provided if the party receiving the credit and giving the rights has difficulty in collecting the credit. The whole money system of the United States is based on extensions of credit. Almost every transaction in the public is based on credit. There is constantly an exchange of value for rights and rights for value happening in the United States. This results in transfers of digits from one account to another. Public to public. A person borrower gives value rights to foreclose, asset on the bank books, for rights from creditor, use of public credit. If he, borrower, gets those rights, uses use of public credits in return for his borrower commitment to extend credit, promissory note. A person, lender, equals the creditor, gives value, use of public credit, to debtor, for rights from debtor to foreclose if he, lender, equals creditor, gets those rights to foreclose in return for his, lender, equals creditor, commitment to extend public credit to a borrower equals a debtor. Person, borrower, lender, gives value, rights to foreclose, use of public credit, for rights, use of public credit, rights to foreclose, in return for, promissory note, extensions of public credit. Private to public. A person, borrower, gives value, private man's credit via signature on a rights from creditor, use of currency, if he, borrower, gets those rights, use of currency, in return for his borrower commitment to extend private credit to the lender from the man who represents the borrower. A person, lender, equals the debtor, gives value, liability on its books, for rights, use of private credit, if he, the lender, gets those rights, use of private credit, in return for his lender commitment to extend public credit, the debtor, to the debtor. Private to public. Person, borrower, lender, gives value, man's signature, liability on its books, for rights, use of currency, use of private credit, in return for extensions of private credit, extensions of public credit. There are two different acts happening in these scenarios. One is public to public, and the other is private to public. Nothing can happen on the public side until someone on the private side signs something. The signature can be advantageous to the man or not. It is up to him. The man is an accommodating party who receives nothing for lending his name or credit to the public event, unless he negotiates terms that are favorable to him. If the United States presents the terms and they are accepted without renegotiation, the man is just an accommodating party and can expect to receive no rights in return for the value he gives by lending his name and credit to the United States. A bank cannot lend its own credit. When a bank extends credit, it has to use someone else's credit and extend it to a third party. It is not a loan, B to C. It is a lengthening of the process, A to B to C. The credit comes from a man, lender, in a private in the private through C, U.S. citizen agent for A, to B, bank lender, in the public to C, U.S. citizen borrower in the public. The borrower is both a debtor and a creditor on the same transaction. The man cannot go into the public, so the U.S. citizen has to represent the man in the public. The U.S. citizen needs hands to sign instruments, so the man has to represent the U.S. citizen and supply the energy. The man will be presumed to be an accommodating party unless he negotiates a contract that has terms more favorable to him and permits his signature to be used with no terms for payment to him. He just waives his rights. The U.S. citizen is both the transferor and the transferee on the instrument in the public. Instruments that are issued and transferred for value are requests for a man's private credit. They are credit applications. He can endorse them properly and be a creditor, or stand silent and be a debtor. It is up to him. The public to public value on the previous interpretation is the right to foreclose an asset on the bank's books and the use of public credit in return for a promissory note and an extension of public credit. The private to public value on the previous interpretation is the man's signature on the note and the liability on the books, the bank's books, in return for an extension of private credit to facilitate the extension of public credit. There can be no public credit without getting credit from the private side first. The people in the several states are the only ones who have credit because they are the only ones with the energy that does not belong to someone else. Fictions have no energy of their own. Since money of exchange is not used in the modern commercial system, credit is the medium of exchange through money of account. Money of account is digits on accounting ledgers. All loans in the public necessarily must be made on the private credit of the people. The people have to supply private credit that public lenders extend to borrowers in the public. No wonder lenders always say they are extending credit. They are extending the people's credit from the private side into the public and returning it to a fiction represented by one of the people. Value is given on both sides. Value is accepted on both sides. This UCC 1-201 definition is in Article 1 of the Commercial Code, so it does not apply to Article 3 negotiable instruments, but it is necessary to understand the duplicity of value to understand A for V. The following interpretation of UCC 1-201, a deal with a public person created by the United States as debtor and the United States as the creditor, as well as the United States as the debtor and a man as the ultimate creditor through the public person he represents. These are still dealing with the person and credit under public policy. Public to public. A person, United States, gives value, certificated security equals birth certificate equals U.S. citizen for rights to use U.S. citizen as surety. If he, United States, gets those rights to use U.S. citizen as surety in return for his United States commitment to extend public credit and benefits the U.S. Benefits to the U.S. citizen. A person, U.S. citizen, gives value pledged to the United States for rights to operate in commerce in the United States if he, U.S. citizen, gets those rights to operate in commerce in the United States in return for his U.S. citizen commitment to extend public credit to be a surety to United States. Public to public. United States person gives birth certificate, gives value for rights, use of private credit in return for public credit and benefits. Person, U.S. citizen, gives value, pledges to U.S. for rights, commerce in the U.S. in return for being a surety for the U.S. Private to public. A person, United States, gives value, certificated security equals birth certificate equals U.S. citizen for rights, get private credit. If he, United States, gets those rights to use private credit in return for his United States commitment to extend public credit distribution from trust to the man through the U.S. citizen. A person, U.S. citizen, gives value, man's private credit, to United States for rights to operate in commerce in the United States. If he, U.S. citizen, gets those rights to operate in commerce in the United States in return for his U.S. citizen commitment to extend private credit of the man who represents the U.S. citizen to United States. Private to public. Person, United States, gives value, birth certificate, for rights, get private credit in return for extensions of public credit. Person, U.S. citizen, gives value, commerce in the U.S. in extensions of private credit. On a public side, the birth certificate represents value as security for a pre-existing claim to the United States has against a U.S. citizen. On the private side, it is a security for a pre-existing claim the man has against the political state for using his description without paying for it. It is an antecedent claim the man can present as a counterclaim when the United States brings a claim against the person the man represents. The birth certificate secures the obligation to the state. The birth certificate secures the obligation the state as an agent for the United States has to the man. Since no payment has ever been made to the man and technically cannot be made, the inches and pounds description of the baby on the application for the birth certificate constituted a symbolic delivery of the baby into the United States. What happens in the United States stays in the United States. The baby and the man cannot go into the United States, but the person named on the birth certificate can. The United States cannot go into the private states, but the man representing the person named on the birth certificate can. The baby grew into a man, and the rights the baby had to payment for the use of his description carry on to the man. If the man does not do something with that certificated security birth certificate, it is considered abandon. Abandon is waste. So the United States will use the birth certificate to prevent waste until the man decides to use it. Subsection B can also be read from several different perspectives. Both parties in each scenario give value and rights and receive value and rights through the agreement. The following interpretation deal with individuals and corporations. UCC 1-201, General Definitions, 44, Value, except as otherwise provided with respect to negotiable instruments and bank collections, sections 3-303, 4-210, and 4-211. A person gives value for rights if he acquires them, B, as surety, as security for or in total or partial satisfaction of a pre-existing claim. Usually a person gives value when he is exchanging them for rights he is acquiring as security for that one transaction. Those rights might be in the title to real property, or capacity to sue, or for performance. According to subsection B, a person, United States, can give value benefits for rights pledged. He, United States, is acquired from a U.S. citizen. A security for satisfaction of a claim that already exists, national debt. The rights the United States gets from the U.S. citizen secure payment or performance on the pre-existing claim the international bankers have against the United States and its sureties. The person giving the value, United States, has supposedly already received a promise of some sort from the United States citizen. Now, the person, United States, is giving value again to get more rights that he will acquire as more security for total or partial satisfaction of that pre-existing claim, national debt. A tax bill is considered value, as is a libel of information for a quasi-criminal case against a U.S. citizen for violation of the United States statutes. The United States is giving value by issuing an instrument for value. That instrument carries a security interest in the instrument that is issued. That can be considered to be value. In exchange for giving the U.S. citizen a security interest in the instrument, the United States is looking for rights in the property owned by the U.S. citizen. It is also looking for a right to seize the body. All of this is done to collect revenue from the U.S. citizen as a surety. If the man who represents the U.S. citizen does not recognize the value that is being given, that waiver does not negate the rights the United States is acquiring in the transaction. In a normal situation, the party giving the rights receives value through the transaction. A right is a remedy. If the party who gave the rights is later accused of not performing, the right he gave as security when he received the value can be used to seize the property to satisfy the terms of the agreement. In subsection B, a pre-existing claim makes an appearance. The United States already wants to repay the international lenders, but if it doesn't pay, lenders can use United States statutes to collect from U.S. citizens. Both parties give value and both receive rights in each transaction. The value given can be absolutely anything that is sufficient to support a simple contract in the jurisdiction where the agreement is made. The rights given can be anything to secure the obligation incorporated in the agreement, including defenses against claims made by the parties against each other. When we come back, we'll be talking about public to public, public to public, and private to public.